Hello, everyone. I'm Darrell Cartwright, an attorney in Birmingham, practicing throughout the state of Alabama. Today, I wanted to talk to you about something called a civil asset forfeiture proceeding. Now, many of you may already know that a civil asset forfeiture proceeding is a civil proceeding where law enforcement can take or seize property that is somehow connected with a crime. And in our minds, we think this is great. Maybe this is the drug dealer's cars or toys of some sort. Maybe this is mafia based. Maybe it's cartel and the assets that they have, bank accounts, money. And that's great if it worked that way. But if it was limited to that, I wouldn't be talking to you today. Instead, in today's all too common policing for profit environment, we see it improperly used. Not only that, we think that it is improperly used to the point where innocent owners can prove that they're innocent, but it takes too long to get their property back, even after they go and hire an attorney to help them in that process. Well, today, I have exciting news. The United States Supreme Court, the highest court in the land, has agreed to hear our petition for a writ of certiorari to decide two cases involving two ladies that we represent, Miss Sutton and Miss Culley, who have been victimized by the civil asset forfeiture procedure. In both cases, Ms. Culley's case and Ms. Sutton's case, their cars were taken. In neither case were Ms. Culley or Ms. Sutton charged with a crime. In neither case was Ms. Sutton or Ms. Culley driving the car or even in the car when they seized it. The city of Satsuma and the town of Leesburg instituted civil asset forfeiture proceedings against both cars and their owners, maintaining that, well, we can do this because we stopped the driver who happened to have some drugs on them in the case. In both cases, we represented the ladies in the civil asset forfeiture proceeding and were successful in obtaining their cars back because they were innocent owners. They had no connection with the crime. In both cases, we were successful at the summary judgment level, which is before a trial takes place. In Ms. Sutton's case, it took over a year for that summary judgment decision to be issued. In Ms. Culley's case, it took 20 months for her to get her car back. That's too long. Justice delayed is justice denied. Our procedure should be in place. A procedure should be in place to afford us basic constitutional due process protections. All of us should be protected by our Constitution. We believe that a prompt post-deprivation hearing should be mandated to allow that innocent owner to come in and say, hey, this is wrong. I'm innocent. I have no connection to this crime. You need to give my property back to me. We think that should be a bare minimum, and that the state, like Alabama and others like Alabama, should be required to give us that basic protection. We hope the U.S. Supreme Court is going to agree with us. We don't know. We know they're interested in the case. We know they think it's of sufficient state and probably national importance that it takes up part of their very, very precious time. They can't hear very many cases. The ones they select are always important. We're hopeful that the U.S. Supreme Court will agree with us, that the procedure is flawed. We're hopeful that the U.S. Supreme Court will agree with us that due process requires that every American citizen be given that opportunity to come in quickly after they take their property and say, hey, this is wrong, give it back. I'm innocent, and don't make me wait over a year or 20 months to get this property back. Don't make me have to go in and get an attorney to file their pleadings and motions for summary judgment and be successful even before the trial and still take that long. I get excited about this, as you can tell. It was exciting news today that the Supreme Court gave us when they granted that certiorari. It's my understanding that every 2 weeks they meet in conference and discuss well over 100 cases. And today, ours was the only one that was granted that cert. Keep your fingers crossed for us. Arguments should be in October, decision by probably next summer, and hopefully we'll get a good decision. If there's anything I can do to help you, you let me know. As always, I'll keep you informed best that I can. And until I see you next time, have a great week.